We have major legal developments tonight, and they look like this, and I'm going to walk you right through them. These are two separate cases where two judges have ruled for major Epstein transparency and basically changed what is longstanding precedent, sensitive Epstein records, specifically to unseal what are grand jury records in the Ghislaine Maxwell case. Now, that mirrors another ruling, and I'll tell you about that as well. But if this sounds like a huge change, it is. Grand jury materials are protected by Rule 6, which is one of those sort of long-standing rules of the federal court system. And the reason the grand jury materials are usually secret is because...
Hi, I'm Elizabeth, and welcome back to another video. I hope you're all doing great. Today we're diving into another major Democratic drama that's making headlines and sparking intense debate.
Recent disclosures related to the release of documents connected to Jeffrey Epstein have created significant political controversy and renewed scrutiny around how the federal government is handling long-requested transparency. According to reporting from multiple news organizations, a new set of Justice Department materials has been released pursuant to a law passed by Congress requiring the disclosure of records related to Epstein's activities and the government's investigations into them. These documents are official government records, not leaks or unauthorized disclosures, and were released as part of a legally mandated process. The law requiring the release of these materials, commonly referred to as the Epstein Files Transparency Act, was passed with overwhelming bipartisan support. The measure cleared the House by an almost unanimous vote and passed the Senate without opposition. The legislation required the Department of Justice to make public a broad range of documents related to Epstein within a specific timeframe, while also providing Congress with an unredacted list of government officials and politically exposed individuals whose names appear in those records. The stated goal of the legislation was to increase transparency, address long-standing public concerns, and provide accountability in a case that has remained a source of controversy for years. President Trump signed the legislation into law in November 2025 after Congress made clear that it would override any potential veto. Following the signing, responsibility for implementing the law fell to the Justice Department. Since then, the department has begun releasing materials in stages, including court filings, investigative summaries, and internal records. Many of these documents contain redactions, which the department has said are intended to protect victims' identities, comply with privacy laws, and avoid releasing unverified or sensitive information. Media outlets including the New York Times, PBS, and The Guardian have reported that President Trump's name appears in some of the released documents. These references do not constitute criminal charges, nor do they, on their own, establish wrongdoing. In many cases, the documents reflect contacts, social associations, or references contained in investigative files rather than findings of illegal conduct. Legal experts have emphasized that being named in government records does not imply guilt, and that investigative files often include unverified statements or third-party allegations. According to reporting, Attorney General Pam Bondi briefed the president earlier in 2025 that his name, along with those of other prominent individuals, appeared in Epstein-related records. The White House has disputed aspects of that reporting, while news organizations have cited multiple sources confirming that such a briefing occurred. The existence of these differing accounts has added to the political tension surrounding the document release. The pace and scope of the Justice Department's disclosures have also drawn criticism from members of Congress and advocacy groups. Some lawmakers from both parties have questioned why the releases have been slower than the law initially envisioned and why many documents contain extensive redactions. In addition, reports that certain files were temporarily unavailable on the department's public website have prompted calls for clarification and oversight. The Justice Department has attributed these issues to technical reviews and ongoing efforts to ensure compliance with victim protection requirements. These developments have fueled broader political debate. Supporters of the president argue that the releases are being selectively interpreted and that references to his name are being taken out of context. Critics, meanwhile, contend that the administration has not moved aggressively enough to comply with the spirit of the transparency law. Analysts note that the situation has created frustration on multiple sides, including among Epstein survivors and advocacy groups who have long called for full disclosure of the government's records. From a legal standpoint, the released materials have not resulted in new charges against the president. Legal experts consistently stress that the documents made public so far do not establish criminal liability, and that many references are incidental or historical. However, the political consequences are more complex. The president has long portrayed himself as an outsider willing to expose elite misconduct, and the perception that his own administration is managing a sensitive release involving his name has complicated that narrative. The situation is further complicated by the fact that not all required disclosures have yet been completed. The Justice Department is still obligated to provide Congress with additional materials, including unredacted information under secure conditions. Lawmakers have signaled that they intend to review those materials closely and determine whether further hearings or investigations are warranted. Some Democratic members have indicated that Epstein-related information could be examined alongside other oversight matters, though no formal action has been announced. Political analysts suggest that the controversy is likely to persist regardless of whether additional revelations emerge. Even absent legal consequences, the continued release of documents, ongoing questions about redactions, and disputes over transparency are expected to remain part of the broader political landscape. The issue also intersects with wider debates about government accountability, the handling of sensitive investigations, and public trust in institutions. Survivors of Epstein's abuse have continued to call for a process that prioritizes truth, accountability, and victim protection. Many have expressed frustration that years after Epstein's death, the full scope of his network and the government's response remains unclear. Advocacy groups have emphasized that transparency should not be reduced to partisan conflict, but should focus on addressing systemic failures and ensuring justice for those harmed. Ultimately, the release of Epstein-related documents has reopened long-standing questions rather than resolving them. The law mandating disclosure has set in motion a process that is still unfolding, and its political and institutional consequences remain uncertain. While the documents released so far have not produced new criminal findings against the president, they have intensified scrutiny of how transparency laws are implemented and how administrations manage disclosures that involve powerful figures. As additional materials are released and congressional oversight continues, the issue is likely to remain a source of political tension. What is clear is that the controversy has shifted from speculation about whether records would ever be made public to debate over how they are being released, interpreted, and contextualized. That debate, rather than any single document, is shaping the current moment and ensuring that the Epstein files remain a subject of sustained public attention.